Welcome to our program on judicial reform in Ukraine. I'm Frank Bailey and the president of Pioneer Public Interest Law Center. We have been operating for just a little over a year, 5 days, more than a year, something like that. A year ago, we were planning a lot, and now I can say that we've done a lot. You will find on the table our most recent newsletter, which will tell you some of what we've been doing. And so I encourage you to take that and take a look at it. So I want to say a few words, but first, because at the end, it always gets lost, and I don't want it to get lost. So what we ran into a challenge this week, and that is Bohdan Vitvitsky, who you see on the screen, and I'll introduce in more detail in a moment, was supposed to be here. But if they told you COVID's over, it's not quite over. And he's in New Jersey, and we have, after some IT struggles, we were able to work this out to have him appear and do what I think will be a wonderful job on serving as the moderator and the questions that we will be working through with Justice Cordy. I want to start with something that always gets lost at the end, and that's to say thank you to a couple of people first. And those people are first from our staff, or Pioneer staff, which is kind of my inherited staff. Annie Anderson, who is all in black today. She was all in white yesterday. I don't know what all that means, but today she's all in black, and you saw her when she came in. And Annie's a millennial. Annie is a millennial. She's not supposed to work as hard as she does, but she really does. When I ask her to do something, it gets done. She anticipates. Thank you, Annie, for making this happen. Thank you. The other person without whom this could not have happened is Sean Wong. You are looking at our IT staff, and Sean, he told me on Monday, we can't do this. He told me on Tuesday, we really can't do this. And yesterday he said, I can do this. So with many contingencies, so I thank Sean that we're able to have the program tonight. And the other person who put this together with me from the beginning is Walter Lupan, attorney Walter Lupan. I have a little something from Pioneer for Walter. Come on up. You bet. Thank you. So this is a labor of love for Walter. His folks were born in Ukraine. He has been here since for his entire life, and is an attorney. He actually spent time working in Ukraine through the State Department, and then decided I better go to law school and make some real money, and that's worked out for him, and it's worked out for me. And I have a new friend, so he and I are going to be fast buddies from now on. This could not have happened without Walter. So again, I thank him very much for his efforts. I've had the privilege of leading the Law Center for the last 12 months, and I feel very satisfied and privileged to report to you that we've had the kind of impact that we were hoping for. Again, look at our newsletter and you'll see exactly what those things are. We have fought to make sure that taxpayers pay their taxes, but not more than their taxes. We have fought to make sure that kids that want to play sports in school can play sports in their schools. These are easy things. We have fought hard to make sure that when people go to town meeting, or if they go to the select board meeting, their microphones aren't shut off. They get an opportunity to get up and be heard. And believe it or not, that took a Supreme Judicial Court case. But those are the kinds of things that we've been doing. So tonight we're doing something very different, and Justice Cordy has been working in Eastern Europe and in Central Asia on judicial reform, legal reform for many years. I've said before that when I was privileged as a federal trial judge to have the opportunity to bring judges from abroad here, he was always willing to have me bring them up to the Supreme Judicial Court, where he told them that 97% of cases in this country are decided by the state courts, so don't be impressed with these federal guys. And he was right about that. But his focus has been, I think it's fair to say, post-Soviet countries, authoritarian countries, and introducing fair and impartial judging in those countries, which is not part of the culture, unfortunately, that came out of the Soviet system. When I was, one of the groups that I brought to see him were a group of Kazakh judges. Most of you have heard this, but this group of Kazakh judges, I brought them to the federal court and met with a judge who had just negotiated a settlement of a $4 billion IP case. And when that was described to them through a translator, the translator, it was a question from one of the judges in Russian, of course, and I couldn't understand this question. It was translated, and the translator, for the first time in a week that I had been with these folks, he said, Judge, I don't think I should translate that. And I said, no, this is just like they said it in English. That's how this works. So whatever it is, we have broad shoulders, we'll hear it. And here's what they said. Hearing about this $4 billion settlement, the judge said, what was your cut? And when we were dumbfounded, of course, we didn't know what the question meant, really. And then we realized what he was saying, and we said, no, tell him. This judge received her salary, that's all she got, and her job, her dedication is to make sure that this happens. They laughed. They didn't believe us. They would not believe us that you would do that work and not get a couple of points out of it, right? Because that's the culture, and that's what Bob has been working on. And I think this, I don't know for sure. I think that Bohdan is going to tell us, is going to lead off today with a description of what was the system in the post-Soviet period, maybe a little of the Soviet period in Ukraine. And I don't think it's too far out from what I've just said. So with that, I'll launch this. And so I guess I do need to tell you, of course, I don't need to tell you that Justice Cordy served on the Supreme Judicial Court. He served as counsel to Governor Weld, correct? Chief counsel to Governor Weld, and is now at McDermott, Will and Emery. And Mr. Vitvitsky served, is an attorney. He served in the U.S. Attorney's Office in the District of New Jersey. He also served as legal officer in the U.S. Embassy in Ukraine and has remained active post his retirement in Ukrainian American affairs. You saw me identify Walter Lupan. Among other things, Walter has served as the president of the Ukrainian American Bar Association and has been a leader in that group during his life. So with that, I'll turn it over to Mr. Vitvitsky and look forward to. If you're listening online, go into the chat and ask your question. All right, and John LaLiberte, who works with us, will ask your question. So thanks for coming, and I'll get out of the way. Thanks, Bob.
Good evening, ladies and gentlemen. As has been advertised, the topic of this evening's discussion is Justice Cordy's legal adventure in Ukraine. But before I ask him to tell us about how he became involved in this project, and what exactly he was told the project would involve and require in terms of his time and attention, I think it might be in order to provide you with some background information on Ukraine and its legal system. So the first question that might arise is, why is it that a country that is 4,500 miles from Boston might need and want the help of an American state Supreme Court justice or anyone else to help reform a part of its own legal system? Ukraine's mathematicians are world class. Its engineers built and flew the Mriya, the largest airplane on Earth, which airplane the Russians unfortunately destroyed 16 months ago during the initial stage of their full-scale invasion. So no need for Ukraine to import engineers to help them reform their engineering. What about doctors in medicine? Actually, prior to the Russian invasion, Ukrainian medical schools were training thousands of medical students from the Caribbean, Africa, and Asia. So probably no need there. So why the need to help reform the legal system? Somewhat paradoxically, the reason Ukraine needs such help is somewhat different from why it wants such help. When in 1776, the 13 colonies in North America shed their colonial past and created a new country, our United States, they were endowed with a very substantial blessing. But when in 1991, over 2 centuries later, Ukrainians shed their colonial past and created an independent country, Ukraine, they were burdened with a very substantial curse. The blessing that the United States was endowed with was the opportunity to adopt, lock, stock, and barrel, the English legal system. The curse with which Ukraine was and has been burdened was the Soviet legal system, with the term legal system in quotation marks. Whatever its various flaws, only some of which Charles Dickens lampooned in his 19th century novels, the English legal system was nevertheless a system that had for centuries genuinely struggled to develop a way in which to address disputes between the state and its citizens and between or among its citizens that was rooted in neutral principles, in facts, and in reason. So a product of that system, and one of your most justifiably famous native sons, John Adams, in 1770, agreed to defend the British officer and the British soldiers who were involved in the Boston Massacre. This, despite his strong antipathy to British rule. Adams agreed to defend the accused British because he believed that everyone, friend or foe, deserved justice in the form of a fair trial. He not only agreed to represent the British defendants, but he actually got most of them acquitted. Ironically, and later tragically for the millions who lived in the Soviet Union, the ideological founding father of the Soviet Union was Karl Marx. I say ironically because Marx spent the last 34 or so years of his life during the second half of the 19th century living in none other than London, England. Yet it completely escaped his notice that the English legal system, again, with all of its shortcomings and however imperfectly, was actually a real thing. That is, a legal system that genuinely sought and struggled to achieve the pursuit of justice. But Marx had earlier concluded that Western legal systems in capitalist countries were completely phony, and that instead of pursuing justice, they were merely camouflaged systems geared towards advancing the interests of the ruling classes. He therefore prescribed that when the revolution came, existing capitalist, i.e. Western legal systems, should simply be tossed into the trash bin. And that's exactly what happened after 1917, when Lenin, Trotsky, and their Bolsheviks co-conspirators staged their coup and then revolution. The existing or pre-existing Tsarist Russian legal system, which ironically had undergone some real reforms in the 1860s, half a century earlier, was just tossed out, and the new Soviet system was gradually substituted. But it was a system designed and conducted with one thing in mind: to serve and defend the interests of the ruling Communist Party and the Soviet state. That is why, in that system, what prevailed was so-called telephone justice. The Soviet prosecutor, who was the alpha male in that system, would call the judge assigned to the case and tell him or her what the outcome was expected to be, and that's how things operated. And that's the system that Ukraine inherited in 1991 when it became independent. It was a system that the Harvard historian of the Soviet Union, Richard Pipes, aptly described as a system of legalized lawlessness. When a year after Ukraine became independent, I gave a presentation before the first International Convention of Ukrainian Lawyers in Kiev, in which I detailed what would happen if I, a recently appointed and proud assistant U.S. attorney, were to abuse my position for personal gain, and how it was essential for the rule of law that such guardrails existed. A group of Ukrainian prosecutors later on that evening came up to me to tell me how strange and foolish I was to think that prosecutors should have to operate under any kind of restrictions. In addition to the so-called Soviet legal system being an instrumental one, its other fundamental flaw was its Orwellian character. If the Soviets had simply come clean up front and declared that the Soviet Union simply didn't need a legal system, that only capitalist countries needed them in order to fool their workers with distractions about some sort of pursuit of supposed justice, then post-Soviet legal reforms would have been much, much easier, because reformers could have been able to start from scratch and try to build a whole new system. But no, the Soviets had law schools, statute books, and people who played the roles of judges and prosecutors and defense lawyers. So any and every legal reform effort in a post-Soviet country has had to deal with the fact that remnants of that entire structure of legalized lawlessness still exist, and that its practitioners are used to pretending that what they are doing is something supposedly related to the pursuit of justice. So this was the system with which Ukraine, which the Russian Bolsheviks had between 1918 and 1923 invaded, occupied, and incorporated into the Soviet Union, was cursed. At the outset, Western legal reformers who came to Ukraine thought that what was needed was just to free Ukrainian judges from control by prosecutors, and that then the rule of law would flourish. But things were not so simple. Everyone who had been brought up in the Soviet legal system was taught and could daily see that what was called the legal system was entirely instrumental. That is, it existed to advance specific interests having nothing to do with what we understand to be the pursuit of justice. From their perspective, justice was some Western fantasy or ruse. So after the Soviet Union dissolved and the legal system in a country such as Ukraine no longer had to serve the interests of the Communist Party or the Soviet government, it was to some extent or some degree privatized. It was seen and used by some significant number of judges and prosecutors as an instrument to protect and advance their own interests, the interests of their clan or the interests of those who could pay them the most under the table. All of this, I hope, explains why a post-Soviet country such as Ukraine might need the help of individuals such as Justice Cordy. But that doesn't explain why Ukraine would want such help. It wants such help because, in contrast to Russia, Ukraine has for the last 30 years developed a very strong civil society that now passionately insists on Ukraine becoming a rule of law country, that desperately wants to return to Europe, and that keeps pushing for the adoption of real and meaningful reform in corruption reduction and rule of law promotion. That is, in part, what the Orange Revolution was about in 2003 to 2004, and that is certainly what the Revolution of Dignity was all about in 2013 to 2014. And now, with this bit of history under our belts, let me ask Justice Cordy to tell us, how did it happen, sir, that you became involved with a judicial reform project in Ukraine?
Well, it's a somewhat long story, but I'll try to shorten it. I was appointed to the court in 2001, and by the end of 2001, the Massachusetts judiciary had become a member of the Russian-American Rule of Law Consortium, a consortium of 10 American judiciaries partnered with Russia to implement under their new constitution adversarial justice, judicial independence, and even jury trials. Massachusetts, being the 10th state to join, was partnered with Siberia. So I spent a fair amount of time there. But in any event, Putin eventually threw us out in 2009 when he decided he really did not need or want independent judges. But before that happened, I think it was about 2008, I was at an event at the US ambassador's home in Moscow and met a up-and-coming Ukrainian lawyer who was there for a conference. And he told me, I'm going to the Kennedy School next year to get some sort of advanced degree. And he really wanted to get to know me. And we became friends. And he did come to the Kennedy School, and we kept interacting. So that was then. Then he went back to Ukraine. But he'll come back. And as a justice on the Supreme Judicial Court, terribly interested in sort of judiciaries around the world, I hosted delegations of judges. They came to Boston, often on their way to Washington, D.C. Probably 30 or 40 delegations in the years I was on the court. And in 2011, indeed, hosted a delegation of Ukrainian justices. And I have a nice picture of me and all of them. And later on, when I went back to Ukraine, one of the judges came up and said, "Your picture's in our courthouse." I said, "Well, great, wonderful." So in any event, after that, I had a conversation with one of our interns at the court who was from Ukraine and was going to law school in Boston. And I said, "So when you finish law school, are you going back to Ukraine?" And she said, "Are you crazy? I'm going to law school to practice law. I'm not going to law school to buy gifts for judges." And I said, "Oh, okay, that's good." She's done wonderfully well here in the U.S. In 2015, I got contacted by the law firm that employed this young lawyer that I had met and who had gone to the Kennedy School. And she was a leader of judicial reform efforts in Ukraine. And she said, "We're running a judicial forum, and would really like to have you come in and participate in that." She was the founder of this law firm and an active member of the Ukrainian Bar Association, which was sponsoring this forum. And I said, "Sure, okay, I've never been to Ukraine." So I went to Kyiv for a week, really enjoyed it. I spoke at some length about judicial independence and why it was important to between the rule of law and judicial independence, why it's important to economic prosperity and growth. It worked out very well. I got to see all the beautifully historic places in Kyiv, and I felt very good about it, but I learned a couple of things. First of all, the lawyers involved in this program were fairly candid in saying that one of the problems is the price of a judge is, you can tell the price by the jewelry they wear. I said, oh, okay, that's very interesting, that's different. And I met with one of the chief judges in the economic court at his office, and he sat there and we were talking about what the economic court does and this, and he turns and he goes, I have 2 phones. I said, yes, I see that. He goes, this phone, direct line to the president's office. I'm going, oh, I don't know why you would need that if you're serving as a judge on the court. But I decided that was the end of that meeting, and we left. But I got a good flavor for, on the one hand, a real interest in trying to change things, and on the other hand, what they were up against. The following year, I was invited to the next judicial forum that was being sponsored by the Ukrainian Bar Association. That would have been the fall of 2016. Now, at that point in time, a couple of things had happened in Ukraine. Number one, there was a law passed that required the electronic, that judges file an electronic declaration of assets and income of themselves and the family that would be available to the public. And a number of judges, not surprisingly, resigned rather than to fill out such declarations. And in 2016, the High Qualification Commission of the Judiciary, which is one of the entities we'll talk about, had been essentially instructed to perform performance evaluations and integrity evaluations of all the sitting judges. And there was an interesting point at which about 1,600 more judges resigned rather than to go through this evaluation process. The High Qualification Commission also was required to appoint a public integrity council of citizens that would focus on integrity-related issues. So all of that had sort of happened, or was happening, when I went back in 2016. And what I was asked to do was to talk about how you build public respect and trust in the judiciary. And my theme was, you have got to be transparent, and you really need to have a relationship with the media organizations, because they're the ones that are going to spread the word about what you do and why it's important. And so you need to have this relationship. Now, I had been the chair of the Judiciary Media Committee of the Supreme Court of Massachusetts for 10 years, and had worked very hard to bring media organizations and judicial institutions together, not to sort of hide anything, but to sort of understand each other and why they were both important to a constitutional democracy. And so I tried to do the same thing in Ukraine. I brought judges and journalists together, and it was like, we've never done this before. I've never spoken to a journalist in my life. Anyway, but that was my task. How do we elevate and create more respect, transparency, etc.? But there was still much to be done, as you can tell. By the end of 2016, I think there were 2,000 judicial vacancies in Ukraine. By the way, they haven't been filled. And the High Council of Justice was required, the High Council of Justice, the High Qualification Commission of Judges, which is on my chart there, which I'll get to in a minute, was going to begin doing professional assessments and also integrity assessments of all the sitting judges. So this was going to be quite an interesting several years, and I'll tell you how that ends up. But so in 2019, I was contacted by the World Bank, and they said, we're trying to do some reforms in Ukraine. There's this commission that's going to be set up to do these various things. Would you be interested? And I said, sure, I guess. I had done lots of work in lots of countries around the world with judiciaries, and this was fascinating. I was interviewed, and they nominated me, and then the commission never got set up. Apparently, there were some issues there. Never got set up. So I figured, well, okay, that's the end of that. In 2021, I was contacted by the State Department, and they said, we would like to nominate you to this new organization called the Ethics Council of the Judiciary of the Ukraine, which was set up by legislation, I think in the summer of 2021, as part of another push toward creating, at least for the future, a judiciary that was not corrupt. The EU was very supportive of this and insistent, essentially, on it happening. And I said I would be interested. And so I'm sorry, I'm probably going beyond the question. I was appointed as one of 3 internationals to the the Ethics Council of the Judiciary of the Ukraine. There were 3 senior Ukrainian judges, one on the Supreme Court, one on the Appeals Court, and 1 retired judge, and 3 internationals, a retired senior judge from Wales, 84 years old, but the most active and intelligent person I ever met who was 84 years old. And he had served on the commission setting up an anti-corruption court in Ukraine, and he was fabulous. And then the former prosecutor general of Estonia, a wonderful woman, really, she spoke Russian, she spoke Ukrainian. That was good. That became the Ethics Council. And that's how I got involved. That's sort of the history of me being pulled along into this extraordinarily interesting and important mission. Go ahead, Bohdan. I'm sorry, I went way behind you. I'm beyond you.
No problem. No problem. Great job. How long is your project supposed to last, and what was its? Can you expand upon what its purpose is supposed to be?
Sure. So, in November of 2021, I traveled to Kyiv to meet my colleagues, the others on the council, and to hire a staff. I have 3 young Ukrainian attorneys working for me, and to then decide on a process. We needed to have rules of procedure as to how we were going to perform our job. We had to have a methodology so people understood what it is that we were going to be looking at and how we were going to be measuring things. And that was the beginning of the project. I'll describe the project. Maybe I should do that now. In Ukraine, as is noted on this chart, maybe I should do the chart thing right now. In Ukraine, there are a number of important judicial institutions. The High Council of Justice is, I think, the most important of all of them. And it consists of 21 members, one of whom is the Chief Justice of the Supreme Court by designation, but that person doesn't do much on the High Council of Justice, really. And then 10 judges elected by the Congress of Judges, 2 members appointed by the President, 2 members appointed by the Congress of Defense Lawyers, Advocates, 2 members appointed by the Conference of Prosecutors, and 2 members appointed by the Congress of Academics. 20 members plus the Chief Justice. That council really runs the judiciary in the Ukraine. They send to the president approved candidates for appointment to the courts. The president cannot appoint anyone who has not been approved by the High Council of Justice and whose name has not been sent to them. The president can say, I'm not doing this. Well, then they'll send some more names, but the president must appoint the people that are sent to them. They also do all of the disciplining and dismissal of judges, the assignment of judges. They oversee the financing of the judiciary. It really, in a number of countries, there are High Council of Justices, but this one really runs the judiciary, so it's critically important. And our job, because the High Council of Justice was suspected of protecting corrupt judges as opposed to dismissing them, and there was a reason for that, was to review the background of all of the sitting members of the High Council of Justice, those that were on it, and there were 16 sitting members, and then to review the backgrounds of any of the nominees from these various appointing authorities for professional integrity and professional ethics and integrity. And if we had reasonable doubt with respect to any of them, they were disqualified. So we didn't appoint people to the High Council of Justice, but we reviewed applicants and said, you cannot appoint these applicants over here. These applicants, we have no reasonable doubt about their professional ethics and integrity. They are eligible to be appointed. That was our job. We thought it would be 6 to 8 months. There were 4 vacancies. We were supposed to review the applicants for those vacancies and then also review the backgrounds of all the sitting judges. As soon as we announced in January that we would be reviewing the backgrounds of the sitting judges beginning in March, 12 of them resigned. So now we don't have 4 vacancies, we have 16 vacancies, and we have a war all of a sudden. And so the work became a little more complicated and a little more intense. Bohdan, I'm sorry, I keep running on. More questions.
That's quite all right. You're filling the picture out very nicely. Let me ask you to drill down a little bit and tell us a little bit more about how on a day-to-day basis you went around, you and your colleagues went about carrying out your mandate.
Sure. I will. Obviously, we all met in Ukraine, in Kyiv, and began the process. We did adopt rules of procedure and methodologies. How would we measure professional ethics and integrity? What would we be looking at? What would the process be for applicants? And what would our investigative process be? It was important to sort of create this mechanism and to have everybody on board with it and compliant with it. Obviously, we now had more than 100 applications because now we had all of these positions available. One of the things that we did have was extraordinary support from civil society. Talk about the Revolution of Dignity in 2014 and the real sort of public pressure emphasis on creating a judiciary which was free from corruption. And civil society was fully supportive of that, and they were unbelievably helpful. ANTAC, Euromaidan, De Jure, 3 civil society organizations that contributed so much. Once the list of applicants was out there, they just went to work. And then I had literally 3 young attorneys that reviewed all the public records, portfolios, just an amazing amount of work. And then we had the National Anti-Corruption Bureau, which also stepped in when they had information concerning some of the applicants and when we had requests that they do some follow-up work. The process was the applicants would be referred to us. They had to file an application with us. We would then conduct this sort of internal review of everything we could get, tax records, all kinds of information, and then prepare written questions to them and allow them to submit additional documents with respect to their answers to these written questions. And once we had done that analysis, determine whether they are eligible to be interviewed. And over the period of time, just check my numbers here. Where are my numbers? Over the 18 months, we had 131 applicants who we considered. And as I say, after written questions and then the interviews, but even before the interviews, 14 of the applicants withdrew once they got our written questions. I don't know what that was all about. And we ended up actually interviewing 112 applicants. Of the 112, 4 were the sitting members. So they weren't applicants, they were the sitting members, the existing sitting members on the High Council of Justice, and then all of the applicants for the vacancies. With respect to the 4 sitting members, we determined that we had no reasonable doubt with respect to 3, but we had significant doubts with respect to the 4th. And he was then discharged. and sued, of course, and went up and down, up and down, up and down in the court system. Eventually, we won. But so we interviewed 112 applicants. Our original plan was, of course, to interview them in person in Kyiv and to live stream the interviews, which we thought would be very important. We began to do that in February, and we couldn't actually get started with in-person interviews. At least the internationals weren't available, but we were available via Zoom, and then there would be an interview by all of us, and it would be in person with the 3 Ukrainian judges. As soon as, and these were live streamed, as soon as the war happened and martial law was declared, we concluded that we needed to continue doing our interviews. Obviously, they would be done remotely. And we really could not live stream them. We would tape record them and release the tape records when martial law was lifted. But these interviews were incredibly in-depth about all family members, all properties, and there was just a lot of information. And a lot of these applicants were from areas where there was an ongoing war. We actually interviewed several applicants in military gear from the front lines. And we just felt that we could not live stream that. It's too much information. Putin had said one of the reasons this was so important that he invade is because Westerners were running the judiciary, were trying to run the judiciary of Ukraine. And we all agreed that we just simply couldn't do it. So all of the interviews then began to not be live streamed, but they were recorded. And they would go 2 or 3 hours. They would start at 3 in the morning Boston time, which is 10 a.m. Kyiv time, up at 2, getting ready, and we would go 8 hours or so. So there was a tremendous amount of work, and a tremendous amount of work leading up to the interviews, with written questions, with sometimes 3 or 4 rounds of written questions. I know, Bohdan, I'm going way beyond what the question you asked, but once I start talking about this, I can't stop. So we finished the bulk of our work at the end of April. We now have 16 members of the High Council of Justice, so it is operational. It needs 15 members to operate. It is operational. There are 4 vacancies, and there have not yet been competitions to fill those vacancies. We expect that in the fall. Of the 112 folks that we interviewed, let me get my notes here, I don't want to screw this up. We found 36 compliant, 55 non-compliant, and 20 withdrew after they were interviewed, and therefore we didn't have to make any finding. Apparently the interviews were reasonably clear as to where it was going to end up. And as I say, there are now 16 members of the High Council of Justice. Civil society is not happy about all of them. They wish we had appointed others and not some, but that's life in Ukraine. Civil society is never going to be fully satisfied, but you do the best you can. And they were incredibly helpful in gathering information that allowed us to take it a step further, many steps further. Okay, Bohdan. Where do we go?
Let me ask you one more specific question about the project, and then one or two sort of more philosophical questions before we open it up to questions from the floor. I was curious, what was the nature of the working relationship between the 3 international members of the panel and the 3 Ukrainians?
The working relationship was, by and large, incredibly positive and collaborative. That doesn't mean we didn't have disagreements at certain points, but I would say half a dozen cases that we had really serious disagreements after all of the work we had done and the conversations we had, the discussions, the deliberations we had following all of the interviews. I got to really appreciate that they were completely dedicated to the mission of the future of the judiciary. And as I say, although we had some disagreements, we had a judge on the Supreme Court, a judge on the Appeals Court, and a retired judge they were all first class, and we all worked really hard together. So we didn't have any huge issues, although we had some disagreements and there were some dissenting opinions occasionally, but that's, having been on the Supreme Court, I understand occasionally there's going to be a dissenting opinion or a concurring one. Yes, Bohdan.
I understand that. All right, let me ask you two sort of more philosophical or reflective questions. You have described for us the Judicial Reform project in which you participated, which was a project to fix a structure.
Yes.
And that, of course, is part of a strategy to produce reform. There is the famous Peter Drucker aphorism that culture eats strategy for breakfast. And more recently, the author and professor of law, Carl Bogus, has reminded us that it is culture that drives politics, policy, and law. Now, to my knowledge, most or all corruption reduction or law reform projects are structural rather than cultural. Yet, as Drucker and others have reminded us, culture is so very important. Did your experience in Ukraine, and not just Ukraine, prompt any thinking on your part about how these issues, and do you have any ideas about how it might be possible to influence culture when it comes to legal reform and corruption reduction in a post-Soviet country such as Ukraine?
Well, culture is extremely important. And I think Ukraine, in particularly the Revolution of Dignitary, sort of expressed a need to change that culture, the culture of corruption. And I think that has been a driving force here. Now, there have been a lot of little resistant points for sure, because there are a lot of interests that are protected through the corrupt market. But it's not like the country itself hadn't begun to grapple with the cultural issues. One of the things, in order to change culture, I think most people, at the end of the day, understand that corruption is wrong. But if it's the only way you do business, that's the way you do business to survive. But if you demonstrate that there are options, and there are punishments, and that there are real options to giving into corruption, you begin to help support that change in culture. We saw that, I'm speaking from my own U.S. Attorney's Office experience, in Boston. We had an enormous decade of corruption investigations in the city of Boston through the 1980s, and indicted about 150 people, both private real estate folks and entrepreneurs and city officials. And the culture was you paid for everything. You paid cash for everything, for an inspection, for a permit, for everything. And that's the way it was. And I'll never forget at the sentencing of one of the principal, I won't mention his name, architects in the city. He said to me, he said, "Bob, if I'd known you were serious, if I'd known really that this was a change, I would have told you the truth in the grand jury. But if I told you the truth, I would never be able to do business in Boston again, because that was the culture." And so it took a decade of demonstrating that there were options to that, and there were penalties that really were available and would be implemented for corruption. The culture changed. Now, I represent people now, many of them were builders and developers that I had before the grand jury in the 1980s. And they tell me, you don't have to pay for anything anymore. It is completely changed. Are all the corrupt people gone? No. But when corruption happens, it is often the case that the individual who's being extorted or asked for the cash will go to the FBI. And we'll have a tape recording. Wonderful tape recording in the 1990s of a state senator seeking a $10,000 bribe in connection with a license. The individual went to the FBI, and there's a great picture of her at a restaurant stuffing $10,000 into her bra. It's front page of the newspapers. I know it can happen. It doesn't happen overnight, but you have to demonstrate real options and real alternatives. And I think that's what's happening here. I hope I hope, sincerely hope. Now, I should mention, because I should go back to that chart for a minute, see if we can put that back up there. The High Council of Justice is really at the pinnacle here, but there's another very important commission. It's the High Qualifications Commission of Judges, which is down there. And they run the competitions when there are judicial vacancies, and so the applicants for judicial vacancies apply there. They get reviewed there. And the applicants that they find to be qualified are recommended to the High Council of Justice that does its own review and then decides which applicants to recommend to the president. The High Qualifications Commission of Judges also was assigned to do something else, and that was that performance and integrity evaluations of all of the sitting judges from starting in 2016. And the Public Integrity Council that worked with the High Qualifications Commission concluded that there were a lot of judges, the integrity of which was in doubt. And the High Qualifications Commission didn't buy it completely, but they did recommend that 43 judges should be dismissed. So those recommendations go to the High Council of Justice. High Council of Justice refused to dismiss any of them. And that sort of reinforced this notion that the High Council of Justice was actually protecting the judiciary. It wasn't there to really serve the public. And I think that's what ended up with the Ethics Council and the focus on that. There's also a selection commission because the High Qualification Commission of Judges has also been dissolved, and a selection commission has recommended candidates. They've gone through a similar process. They've recommended 32 candidates. There are 16 members of the High Qualification Commission. They've recommended 36, and the High Council of Justice selects the High Qualifications Commission. So there's a process that's about to conclude, which will have a new High Qualification Commission so we can start actually appointing judges. They've got to do the competitions. The recommendations have to go to the High Council, then they go to the president, and hopefully some of the 2,000 vacancies will be filled with judges for the future. Sorry, Bohdan, I'm off on my own again.
No problem. One last question, and I'll bring it all somewhat closer to home. Has your experience with foreign law reform projects made you any more sensitive to the question of whether we Americans take the maintenance and preservation of the rule of law much too for granted? Former Judge J. Michael Ludig of the U.S. Fourth Circuit Court of Appeals and a constitutional scholar has recently warned that our democracy and our rule of law is as imperiled as never before in our 246-year history. But perhaps strangely, there has not been a peep out of any of our law school or law schools or law school deans about any of this. I mention this because when I have presented before and written for Ukrainian audiences, I have frequently said that in the United States, law schools are part of the structures that help maintain and articulate the societal expectations that rule of law requires in order to continue to exist. I now fear that I may have been mistaken about our law school's willingness to react to the perilous situation that Judge Ludig has described. Do you have any thoughts about any of this?
Well, a couple of answers to that. One, every time I land in Logan Airport, I kiss the turf. I have done 37 international trips working with 10 different countries, and I always come back so grateful for what we take for granted here. To give you an example of one of the countries I have spent most time with is Uzbekistan. And there's been tremendous changes in Uzbekistan, moving toward an independent judiciary, adversarial justice, rule of law over the last 10 years. And one of the things that they have asked us to do, and we have been doing over the last 4 or 5 years, is working with law schools, sort of to do that training in law schools. What do you expect? What are what are the important things that you as young lawyers have to keep in mind about our system, about the system, the rule of law system, why it's important? And so we've worked extensively with the law universities in Uzbekistan. I don't know much about the law universities in Ukraine. I was working diligently in Turkey with the Justice Academy until Erdogan decided he didn't need any independent judges. All of these people, they decide they don't need independent judges. And it always happens as soon as reports come out about corruption in their administration. All of a sudden, we don't need this. But I do agree that we take a lot for granted here. And I do agree that these are issues we need to be concerned about. And law schools should play a more active role in discussing, promoting, supporting the rule of law matters that we take for granted. So, yes, I agree.
Thank you very much. I don't know what the mechanism now is for passing the mic on to whoever has posed questions, because obviously I'm not in a position mechanically to do that. But I defer to whoever or however that's going to happen.
The microphone man.
Yeah, so we can bring it to you.
Yes,
so raise your
please.
hand if you have a question.
Brackett has a
John,
question.
If you would, please.
Uh-oh.
Bob, this was a brilliant presentation. I mean it.
Yeah, you're right.
You know, the culture part is really important, but you also know I'm passionate and you're passionate about measuring too. So how do you measure success in the Ukraine?
God, I don't know the answer to that question. That's a really good question. How do you measure success? Well, in part, we have these civil society organizations that are very focused on the performance of the courts. And they have made huge contributions to creating a new High Council of Justice, which is hopefully going to do what it's supposed to do, and that is to dismiss judges who don't have integrity and ensure that the judges who are appointed have it. I think we have to wait a few years to see what civil society says about how the courts are working. They are being paid attention to. Now, I will say, because some of you may have heard, I've told this story earlier this evening, that in May, or actually April, I guess, starting into May, the Chief Justice of the Supreme Court of Ukraine, the State Department arranged a big trip to the United States for the Chief Justice to meet with the U.S. Supreme Court and to give lectures and to blah, blah, blah. Big deal. He returned in early May and was arrested for soliciting a $2.7 or $2.9 million bribe in connection with a major case that he had decided in April involving an oligarch. They conducted a search warrant on his house, and there's a wonderful picture of a couch with $450,000 on it. Two things that means to me. Number one, of course, it reinforces the public view that the courts remain corrupt from the top to the bottom. And number two, hopefully it reinforces the importance of our mission, that future judges will not be like this judge. But he's in prison. I guess the money has been seized. He was, of course, a member of the High Council of Justice by reason of his position, but he's obviously been discharged from that. So I don't know, Brackett. These things happen, and you can just do only what you can do. And hopefully we can measure it a couple of years from now. We'll see. Yes. Oh, I'm sorry. Microphone person?
While you're walking, John Liliberté, were there any questions from the online attendees?
Yes, we actually have two questions.
Let's do one of those and then
Sure.
in
Okay.
person.
This is addressed to Mr. Vitvitsky, excuse me. Thank you. I'm
Yeah,
sorry,
it's
the
not.
mic-
Hold that up.
This is thank you for being here tonight. Please accept our best wishes for Ukrainian success in repelling the Russian attack on Ukraine. Question is, in some way, odd way, might the war have put Ukraine on an international stage that will end up accelerating its development both economically and democratically?
Obviously, predictions are extraordinarily difficult to make in these kinds of areas. I think there is reason to believe that the war will help speed up some of these reforms. And the basic reason, and again, I speak with relatives in Ukraine on a weekly basis, and some of them are actually involved in government on the local level, and so on. And I have asked them this question because it's one that's occurred to me. And the answer I get is that it's likely that there will be much less patience for the kind of shenanigans that have gone on for some time. The reason being that you're going to have a very large number of veterans, very large number of people who actually risked their lives or had relatives die in the war, or themselves lost limbs, or had relatives lose limbs, and so on. So people are going to feel that they put everything on the line, and they are not going to put up with some of the indignities of having to deal with corruption, particularly in the judiciary, because corruption in some of the other areas has been reduced more significantly. So my suspicion, although again these things are social processes are extraordinarily difficult to try to predict, but I think there's a reasonable chance and good reason to believe that the war will. However, the war is horrendous, as we all recognize, but I think there's a decent chance to think, or a good basis to think that the war may well expedite the kinds of reforms that we're talking about, for the reasons I've mentioned. The other thing is, I have long held and have promoted the view in Ukraine that to reduce corruption, you need to do three things simultaneously. Number one, you need to engage in an intensive educational campaign, the kinds of things that the justice has talked about in terms of explaining to everybody who will listen why corruption is harmful vis-a-vis democracy, vis-a-vis the development of the economy. And I've done that kind of thing for over 30 years in front of various fora in Ukraine. So you need intensive education, explanation, why engaging in corruption isn't just a private affair, it affects the welfare of the entire country. Number one. Number two, you need effective law enforcement that could go after corrupt actors. And that has been built up. The National Anti-Corruption Bureau, the Anti-Corruption Court, etc. So that, and the prosecution, and now the court. So that is operational. And thirdly, you need to pay people decent salaries. And that's complicated because there are too many public servants in Ukraine, which is sort of an overhang from Soviet times. You need fewer public servants, but you have to pay them more. I mean, both the justice and I were assistant U.S. attorneys. We didn't get rich during that period, but we were able to lead decent lives in terms of our salaries. And one of the problems in Ukraine traditionally was that there was a huge number of public servants of all kinds. They were paid very small salaries, and they needed to supplement them by engaging in corruption. So again, in my view, those three things have to happen simultaneously, and they appear partially to be taking place.
I must say, when I was there in 2015, my sense was that when judges were appointed, they were essentially given a franchise. They made very small income, but they got a franchise to collect as much as they could possibly collect. And that's just not the way you want to run a judiciary. Sorry.
Thank you very much.
Go ahead. Yes.
Judge Cordy, when you interviewed the interviewees, what were the questions that you asked? Were they name, rank, and serial number? In other words, very specific items that had essentially one answer, or did you interview them about their values and the application of the law to situations? And did you, among your interviewers, rate them in terms of whether or not you believed their answers?
That's a good question. One of the things that you need to know is we were not appointing people. So to a certain extent, some of the issues that the appointing authority had to consider, obviously we were very interested in integrity and ethics, which is a large focus of what we were questioning about. But they did each write a letter explaining why they wanted to be on the High Council of Justice, what their aims, ambitions, and hopes were. And we usually did ask questions about that to the extent that the letters needed to be questioned a little bit. But largely, we looked at their professional experiences, their personal circumstances, family circumstances, assets, income, going back even a generation or two, just to sort of understand how they got to where they were and how they got the things they had or access to the things they had. We found a lot of very wealthy mothers who apparently bought homes and cars for their children, who were judges, of course. And we spent a lot of time trying to figure out where the mothers got all the money. Because there were a number of schemes which we were made aware of, one of which was the PhD scheme. If you're a judge and you get a PhD, you get a huge salary increase. So there were some faculty members that were known to, give you a positive thesis review, maybe even help write your thesis, get you a PhD for a price. And that was something we looked at very carefully. We found a number of theses that were clearly plagiarized from other materials, and we looked at that. Another scheme was, of course, driving under the influence. The law in Ukraine was bizarre. If the cases weren't resolved in 90 days, they got dismissed. And so, if the judge delayed and delayed and delayed, oh, I'm sorry, it has to be dismissed. There were payments usually made in connection with those. So we did sort of learn about a lot of different schemes, and we had to make sure that we were, that none of the judges or none of the applicants sort of fell into those categories. But the questions were wide-ranging, and the interviews went 2 or 3 hours. I'm sorry.
Those judges that resigned, did they resign sort of en masse because they objected to being judged by outsiders, or you just think most of them were corrupt and they wanted to get out before they got caught, or what happened there? That's
a good question. I don't know how to quite answer that. Surely some of them might have used the fact that there were Westerners involved in the decision-making, although we were 3 and 3. Some of them might have used that excuse, and others just, I don't want to have to put up with this. But it was quite curious. The fact that we'd had, again, in the sort of 16 to 17 period, 2,000 judges resign rather than to file electronic declarations and go through an assessment, a professional assessment, that spoke loudly. And this is just another example of people jumping off before they could get investigated. And indeed, we were amazed at the number of people that withdrew their applications after they were interviewed. It's sort of like, okay, I don't want to go there. I don't want to have a decision out there saying that there's reasonable doubt about my integrity. So I'm out of here. But I don't know the answer.
Well, maybe we'll do one more. All right, John, your pick.
I'll be quick. Just a quick question. Do we have a High Council of Justice in our state as well?
No. We have a judicial nominating commission that reviews applications for the court and sends up recommended candidates to the governor. The governor doesn't have to appoint them, and the governor can appoint whoever he or she chooses, but that process is a very important process. And it's the council is usually made up of high quality, high profile lawyers, retired judges, academics, and it's been a very important part of our system for 50 years.
So if integrity and being unethical, does that have any, is there anyone who oversees that in our state?
Oh yeah, well the Judicial Nominating Commission does an extensive, I served time on that council, I sort of supervise that council. They spend a lot of time checking those things, not to the same level. They don't send investigators out to investigate everything and have civil society pour in with information. But those things are important and they are reviewed, and the applications, trust me, are extensive. So those things are carefully looked at.
All right. One more. Go ahead, John.
Thank you. Just going back in terms of your process, and I did have a question about whether or not the people in the High Council is remuneration now at a level that they have a decent lifestyle. But tied into that, you said in the vetting process, and I wanted to better understand this, you said you engaged civil society. Did you just engage representatives of organizations of civil society, or did you publish candidates and solicit broadly names that were put forward to you for feedback?
The latter. Yes, we published the names of the applicants in advance, and these organizations really responded with lots of robust information. It was really incredible, I thought. There's one question over there. She's been raising her hand for some time. Not you, I know you, you're one of my partners. No.
I have a question that is going to require you to think about your raw data.
Think about what?
Your raw data. Okay. So we're talking a lot about Ukrainians asking for help. And sometimes when they ask for help, it's not explicit. And you gave examples of the ways in which they reveal their understanding without explicitly saying so. So if you looked at the sorts of information that you gathered through the interviews, through your conversations with Ukrainians, what would you say? And if you can't answer it, it's okay. I don't want you to make something up. But what would you say they might be saying about what they think they need in this justice reform? Because it could be very subtle, right? It could be an allegory. It could be a metaphor. Like what did you hear? Because you've clearly seen like hundreds of hours of videotape and interviews. You know something. Tell us what you know, please.
Well, I don't really know how to answer that question. I mean, we got to know these candidates pretty well, and got to have a sense of what they were trying to accomplish, or what they thought they would accomplish as members of the High Council of Justice. Some of them weren't very good at expressing themselves in that regard. Others, we couldn't figure out why the hell they wanted to be on the High Council of Justice, except that they would be important. I don't know if I can answer that question. It was a hard question. Sorry.
Let's. Okay. I think it's time. There are a couple of things that I want to answer your question a little bit about federal, right? And the answer on federal is we have the Federal Bureau of Investigation, and every federal judge has a background check. And that background check takes anywhere from 3 to 4 months, and having gone through it myself, I can tell you there is no stone unturned. So we certainly do it on the federal level, and the application is robust, et cetera. So we do our best. The founders here address some of these issues, and it came from the Massachusetts Constitution, right? So we appoint federal judges generally for life. And there are two other provisions in our Constitution, Article 3, that matter a lot, right? Appointed for life, salary, and, well, second, two, salaries cannot be reduced. Why is that? Because what the king would do is, if he didn't like the outcome of a case, he would reduce your salary, right? And say you've got to go, or fire you. But if you're appointed for life, we try to get around that, right? So we have some things that are baked in here. Why does all of this matter? When I worked with Bulgaria before I went on the bench. Adam is the consul for Bulgaria, and I represented a medical device company that inquired about investing in Bulgaria. This is more than 15 years ago. The wall had come down, and if they could build a plant in Bulgaria, they could get to the Middle East very easily, and they were very interested in doing it. But when and I made some introductions, they went and they looked, and it would have been a really important and good investment in Bulgaria. The problem was, they came back and they said, if we get into a dispute, and we will, we can't count on the outcome of that dispute being adjudicated fairly. So does this matter to Ukraine? For investment? Enormously, right?
Yes.
They have to come through this. So I can't thank first Bohdan Vitvitsky enough. He is coming in with COVID from New Jersey, and it is for the love of his country. That's all I can say. The love of the country of his forebears. So please, let's give him first. And Justice Cordy, 37 trips, 10 countries. What enormous impact! It's just an outsized impact for Massachusetts. I hope you feel the pride that I do, that we have someone like Justice Bob Cordy, and for God's sakes, he's on our board. So thank you.
So when I was first in Ukraine, since I spent a lot of time in Russia, somebody asked me a question, and I said, da. And they said, what? It's duck. Oh, okay, it's duck. So that. Thank you all.